We will call three cases, those being 2019 CR1293, 2020 CR240, and 2020 CR314, all captioned State of Kansas versus Justin Holtsclaw. Would the parties announce their appearances, please?
May it please the court, Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas in all three matters.
May it please the court, defendant appears in custody by Zoom with counsel Anthony Russo, also by Zoom.
All right. We are here set down for sentencings in all of these cases. They all came on together back on January 25th, at which time there was a plea agreement in which various pleas of guilty were entered in the three cases. The court inquired and accepted, continued these cases for sentencing in order to pre-sentence investigation. I've received those pre-sentence investigations in each of the cases. The critical findings are as follows. In the 2019 CR1293 case, the sole count of conviction is one of theft. That is a severity level 9 non-person felony. The defendant's criminal history score was found to be that of A as in Adam. That would leave him with a presumed sentence of prison with a presumed underlying range of 15, 16, or 17 months. If he has to do that time, he'll be eligible for up to 20% good time credit and subject to a post-release supervision duration of 12 months. If he's granted probation today, it would be for a period of 12 months to community corrections. In case number 2020 CR240, the sole count of conviction is one of aggravated violation of the Offender Registration Act. That is a severity level 3 person felony. For purposes of scoring, given the cross counting of these cases, he's a criminal history B as in boy in this case. That would leave him again with a presumed prison sentence with a presumed underlying range of 206, 216, or 228 months. His maximum good time on this would be 15% and subject to 36 months of post-release supervision and 36 months of probation. Two special rules apply to this case. That's number 9, committed while on parole, and number 46, the Offender Registration Act violation. Finally, in case number 2020 CR314, the count of conviction is one of possession of methamphetamine. That is a severity level 5 non-person drug felony. Again, the defendant's criminal history score in this case is A as in Adam. That would again leave him with a presumptive prison sentence with a presumed range of 37, 40, or 42 months. 20% good time credit eligibility, 12 months of post-release supervision, and 12 months of probation. Special rule number 9 applies to this case as well. That's the crime being committed while on parole. I would ask you first, Mr. Schneider, did you have an opportunity to review these 3 pre-sentence investigations? Any additions, corrections, or challenges to those findings?
I have reviewed them, Your Honor. I have no additions, corrections, or challenges.
Mr. Russo, same question.
Thank you, Judge. I did get a chance to visit with my client in the jail and review those documents, and we have no additions or corrections and no challenges to the criminal history scores as announced by the court.
All right. Given that, I will adopt the findings of the 3 pre-sentence investigations for purposes of today's hearing. Mr. Russo, you filed a motion for departure. Would you like to be heard on that?
Yes, thank you, Judge. Basically, would ask that the court find that substantial and compelling reasons do exist to depart when taken as a whole. From the beginning, when my client contacted me and got me on the cases, he wanted to take responsibility, and so he's taken responsibility from the beginning that I've been involved in, and therefore, and did not require the state to prove his guilt beyond a reasonable doubt, which saved the state both time and money. He has been evaluated by Gus Torres at a Positive Solutions for Life, which was one of the requirements of the plea. That evaluation showed that my client had a dual diagnosis with both substance abuse issues and mental health issues that kind of go along with kind of how the registration case occurred as well, to kind of provide a little bit of background that the court may or may not be aware of. My client was involved in a horrible accident that included a traumatic brain injury. It was during this period of time when he was relearning who he was and how to do things. That's when he had stopped reporting during a period, and that led to several of these charges. But based off of the recommendations that were made by that evaluation, there are treatment places available and treatment options that would be better to promote offender reformation rather than sending him to prison, that he can get help for his substance abuse issues and his mental health issues. And that, of course, would go along with the drug case. Most of his crimes that were occurred were due to furtherance of his drug use. He committed crimes to keep his drug use going. And so we believe that treatment would be a much better option for him. We were able to negotiate this to request a departure, and would ask that you depart on all three cases and grant him probation for him to get this help with the substance abuse and the mental health issues.
All right. Mr. Schneider, I would hear your comments on defense's motion and anything else touching upon sentencing.
Your Honor, as to the motion, the state, pursuant to the plea agreement, does not oppose it. Mr. Russo pointed out certain mitigating factors that apply in these matters that come into play and that make the motion well taken. And we would ask the court to follow the plea agreement. As to sentencing overall, my comments would be similar. Judge, I would ask you to follow the plea agreement.
All right. Now, Mr. Holtsclaw, is your opportunity to tell me anything you would like me to know in mitigation of your sentence today.
Yes, Your Honor. I realize that there's no drug addiction worth me spending the rest of my life in jail. And I understand that as I sit before you, that's exactly what I'm facing. And I understand that a person ain't going to change until that person's really ready to change. And I'm really ready to change to show that I can change, and the justice system does work for those who want it to work. And I'm just ready to get my life together and be mature and be a working civilian, and have a chance to spend my life with my family and not behind bars.
All right, thank you. Mr. Russo, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. Well, I will tell you this, Mr. Holtsclaw. Look, I'm not going to keep you in suspense. I'm going to grant your attorney's motion. But I need to tell you, I normally have somewhat of a difficult time with the severity of the offender registration laws. It seems to me sometimes, I think if somebody is clearly trying to evade detection of where they're at and what they're doing and not doing that, then I don't have as big a problem with them. Sometimes I think it's when people are just not taking care of business, something like that, that they find themselves with this high-level felony and long stretches of time. Now, in this particular case, I don't have as big a problem because I see that we have a couple of new offenses that go along with it. So I am not so, I guess, I won't say offended, not so concerned about the severity of the underlying sentence that you're about to get here. And I need you to understand this. I think you are telling me the exact right thing, and I have no reason to doubt you. And I really do hope that you are 100% honest and dedicated to what you just told me, because if you get back in trouble after all of this, I mean, look, here's, I'm not going to keep you in suspense any longer. I'm planning on your highest level here, this offender, to give you the standard range and to run everything else consecutive. To me, that's enough because I look at it 216 months. That's what I'm just ballparking here, 16 years. So I think you should have plenty of motivation. And look, I hope that, like you said, sometimes no matter what the penalty is and how harsh it is, it's not enough to convince somebody or to help them be successful in changing their way. So if you put it together with what you told me about today, it should be enough, and it needs to be, because if you come back in front of me after all of this, and getting the incredible break, I would be remiss if I didn't tell you what a job your lawyer did to take something that I'll be frank with you is real easy for the state to prove, that looks like it should give you 16 years in prison and work you out a deal that you get probation. So I think you need to know that you're a very lucky gentleman in my estimation, and that you're going to need to take advantage of that because, like I said, if you come back and there's some more crimes or you're refusing to register again, you're not going to give me any choice but to send you for all that time. Is that clear enough?
Yes, Your Honor.
All right. Well, given all that, let me go ahead and pronounce sentence. For in case number 2019 CR 1293 for the offense of theft, severity level 9, non-person felony with a criminal history score of A, the defendant will be sentenced to the standard range of 16 months. If he ever has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. In case number 2020 CR240 for the crime of aggravated violation of the Offender Registration Act with a criminal history score B, he will be sentenced to the standard range of 216 months in the Department of Corrections. He'll be eligible for up to 15% good time credit and subject to 36 months of post-release supervision if he ever has to do that time. And finally, in case number 2020 CR314 for the crime of possession of methamphetamine with a criminal history score A, he will be sentenced to the standard range of 40 months, eligible for up to 15% or 20% good time credit and subject to 12 months of post-release supervision. All of these sentences are ordered to run concurrently with one another. And the motion for departure or the application for probation is considered and it is granted. And I do adopt as the substantial and compelling reasons those set out in the defendant's motion and with defense counsel's statements today. Mr. Holtsclaw, let me ask you this. When you get out of jail today, what's your plan for making ends meet?
To get a job and work, I have 2 trades. I have a NCCR in residential electricity. I also have an NCCR in masonry.
Okay, good. It sounds like you should be able to get employed. So I'm going to assess court costs in all 3 cases. I'm only going to assess a supervision fee in one. Let's call it the 2020 CR 314 because that's the one that I have open right now. I will waive the supervision fee in the other 2 cases, given that they are, he will be supervised just the one time for all of them. Mr. Russo's retained, there's no attorney fee there. It says payments required under the database fee, but I believe the defendant is already in the Kansas database, given his prior felony convictions. I just want to make sure, yes, they're from 2016. So that should be fine. There's not going to be
Judge,
any.
I'm sorry. You got muted again for,
Close my email. So it cuts out my mic every time I get an email. So he doesn't have to pay the KBI database fee, and there's not going to be a fine. So it's going to be limited to the 3 court costs in each of the case.
Judge, how long is probation in 191293 and 2314?
The controlling term of probation, remind me, the longest term was,
36.
Well, it's 12 in 1293. I believe it's 12 in 314 as well.
let me look. 12, I thought one term was longer than the other. I'm
In
going back.
240, it's 36 months, and you mentioned that.
Yeah, that will be the controlling term, and we might as well make all of them that long since he'll be on during that time. So 24 months of probation, 2 community corrections.
Judge,
in
24 or
each-
36.
With the 3 cases, it's 12, 36.
I
and-
understand, but I'm not running them consecutively. So the longest term is in 240, and it is a period of 36 months.
Yes.
Yeah.
That will be the controlling term in all 3 cases. All right. So we've gone over all of the fees and all of that. Mr. Holtsclaw, you have 14 days from today to appeal anything you don't like about your sentence. You also have the right to seek expungement after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that?
Yes, Your Honor.
Gentlemen, other things we need for our record today?
I don't know of any, Judge.
I do want to make the court aware that he does have a hold out of Johnson County, and that he'll be going there next. So even though you've granted him probation, I just want to make sure everyone knows that he won't be reporting immediately. But as soon as it gets to Johnson County, we can resolve that. Then he'll be back to work on that.
Right. All right. Then if there's nothing else, I'm going to adjourn. I'll stop.